Raymond and Gertrude Scowron owned a private rural road, which was intersected at one point by the railway operated by Consolidated Rail Corporation. It was just a standard level crossing on a private road, seldom used by anyone not very familiar with it. There were no signs, boom gates or other warning devices. On the 27th of September 1994, Craig Clementoni was in the area and successfully used the private road to cross the railway line 3 times. He knew full well that the railway line was active, and on each of the 3 occasions he slowed down and looked carefully in each direction before crossing. On the 4th occasion he wasn't as cautious and disaster struck. A train collided with his car, causing him serious injuries. He sued the railway, but he also sued the Scowrons, arguing that they had a duty of care to warn him of the rail crossing, and their failure to do so led to the accident. It's obviously not controversial that a landowner, an occupier, has a duty of care towards people on that land. But if you think about it, Clementoni was arguing that the Scowrons, the road owners, owed him a duty of care to warn him about a danger on someone else's land, because the railway was responsible for the land where the tracks were. The railway was responsible for the train which hit him. The court wasn't prepared to find that duty. Citing an earlier case, their honours said, as a general matter, a landowner owes no duty to warn or protect others from a defective or dangerous condition on neighbouring premises unless the landowner has created or contributed to it. In this case, the level crossing had been there for many years before the Scowrons became the owners, so they couldn't be said to have contributed to the danger. The last-ditch argument for Clementoni was that by failing to sufficiently cut back the vegetation on their premises, they had prevented him from being able to see the train. The court refused this argument too, for much the same reason. They were under no obligation to make it easier to see a danger on someone else's property. From this case, we learn that the duty of an occupier usually only relates to dangers on their own land and not dangers on adjoining land.